Hello everyone, I welcome you to another video by Legacy IAS where we are continuing our discussion of the dispute resolution mechanisms and institutions which are there in the country. And in this particular video, we are going to talk about how exactly the lowest level of our governance needs to be strengthened. Now, the vision that Mahatma Gandhi had towards a bottom up approach, whereby the democracy is where if our strongest of villages, if our villages become the strongest unit as far as the democratic structure is concerned. In this regard, we cannot accomplish the particular objective if, besides providing, let's say, political equality and social equality, we also provide them with justice. So, the kind of justice that a village would require might be, in terms of the conditions in which they are operating, kind of different from what, say, the district court or the high court or even the Supreme Court would legislate into. So, in that sense, in order to bring that bottom up approach, that customization, that specialization with regards to the village that is in context, the concept of gram nyayalayas has been brought into place. So this is what our discussion is going to be, whereby we will discuss the entire justice system which is there in the rural side of local governance, which is the panchayati raj system. So this is what we're going to discuss in our particular video today. Now, as far as the entire vision behind this concept or this idea of Gram Nyayalaya arose, it's actually started from Article 39A of the Constitution, which is kind of a directive to the state, okay, whereby the state is actually asked to provide or ensure a legal system that is meant to promote justice on the basis of equal opportunity, and this particular opportunity, which means accessibility, has also to be supplemented and complemented with affordability, which means free legal aid as well. So, not just that you're making the provisions, the situation available for them, the opportunity to seek justice available for them, but also at a no cost level. All right, to ensure that the opportunities for securing justice are not denied to any citizen. So this is not necessarily for the non-citizens, but it is particularly for those who are citizens of the country by reason of economic or other disabilities. So any kind of economic challenges that people may have or any other kind of disabilities that they may have, that should not be a hindrance towards providing justice to them. Also, the preamble to the Gram Nyayalaya Act envisions providing justice to all citizens at their doorsteps, which means that the time travel to, let's say, a district court, high court is something that is being cut short to ensure that the opportunities for securing justice are not denied. So that is the vision and the mission behind this idea. Now, as far as this particular Gram Nyaya is concerned, the idea is to provide justice to the poor as well as disadvantaged, which actually in today's time, even in the 21st century, is a problem which large parts of the world also face. So different strategies and approaches have been adopted in this context. All right, these included that you simplify the different laws which are there so that it is comprehensible for the local public who are not so educated, not so aware. Incorporate alternative dispute resolution mechanisms like arbitration, conciliation, as well as mediation. So, in this regard, lot of these alternative approaches are also being suggested. The idea is to provide speedy, inexpensive, and substantial justice to common man, to have a much more faster way so that justice is provided to them without getting delayed, in an inexpensive manner, affordable manner, and also substantial justice is provided so that it is not just for the sake of providing. So, in this regard, the Law Commission of India, in its 114th report on Gram Nyayalayas, suggested the establishment of this Gram Nyayalayas. Accordingly, this particular act has been enacted to provide for this establishment at the grassroots level. All right. So, in spite of the disabilities that they may have, the concept of justice needs to be provided to them. There are several Gram Nyayalayas which are there in operation throughout the country. Now, these Gram Nyayalayas are going to be essentially a court of judicial magistrate of the first class, and its presiding officer, who's also called the Nyayadhikari, shall be appointed by the state government after consultation with the High Court. So the appointment, the responsibility of the appointment has to be given to or is given to the state executive. But this particular executive appointment is to be done in consultation with the High Court. This particular Gram Nyayalaya is to be established for every panchayat, but at the intermediate level or as a group of contiguous panchayats at the intermediate level in a district where basically there is no panchayat previously in that particular state. Also, the Nyayadhikaris who are going to preside over these Gram Nyayalayas, their conditions are that they are judicial officers, they are drawing the same salary as well as enjoying the same powers as the first class magistrates which are there of the High Court. So they are judicial officers who are placed in an equivalent position to the first class magistrates in terms of the salary drawn and the powers and functions that they have. They basically exercise powers in both criminal as well as civil courts. So the state government is basically now going to, when they are appointing this particular Nyayadhikari, representation needs to be given to scheduled castes, scheduled tribes, women and other classes and communities which require the necessary representation. They are basically not bound by the Indian Evidence Act. In fact, more or less, they are bound by the principles of natural justice. See, the whole point is that we cannot complicate the element of justice at the lowest level of governance and society. We're talking of people in the rural areas who really don't have access and understanding to complex laws and systems. So principles of natural justice are more often than not used as the basic standard principle for practicing such laws. Also, they need to have a kind of a mobile court, all right, exercising both criminal as well as civil jurisdiction. This is essentially to ensure that people don't really have to travel too much and we have more like justice coming to their doorstep as a very, very novel concept. All right, this particular position of the Gram Nyayalaya is going to be at the headquarters of the intermediate panchayat. All right, the three levels of panchayat which is there at the intermediate level, we are supposed to have this. Now, they are going to try civil, criminal and other disputes, all of which are mentioned in the second and the first schedule of the Gram Nyayalaya Act. So, both the central and the state governments, both of them have been given the power to amend these particular schedules of the Act. Now, the Gram Nyayalaya shall try to settle the disputes as far as possible by bringing out conciliation, which means through conciliation they are going to try to resolve the disputes which are there amongst the confronting or the conflicting parties. They are going to be guided by this principle of natural justice, but this particular principle needs to be subject to, or rather unless there is a particular rule that is being mentioned by the High Court in this regard, they are going to be guided by this principle of natural justice. Now, any appeal that is going against this particular Gram Nyayalaya, so the appeal in civilian matters are the ones who will go from the Gram Sabha all the way to the district court. All right, which is going to be heard and disposed of within a period of 6 months. So we're trying to make it speedy. We're trying to expedite and create a procedure that within this time period, all amount of effort needs to be put in order to make it, in order to close it. So these Nyayadhikaris, which are basically drawing the same salary, these judicial officers are the ones who are responsible for ensuring that this speedy justice is provided. Now, there are several advantages of having these Gram Nyayalayas. Firstly, that you are providing justice to the lowest level of governance. We are trying to ensure equal access to justice. So, there is access, there is availability. All right, we're trying to reduce the burden of the district court. So trying to transfer some of the cases from the district court to these Gram Nyayalayas is trying to reduce the burden, and under pressure when they might kind of in the race of speedy justice, no wrong ruling can come out, so that is also indirectly ensured. So the speedier justice is ensured by reducing this particular burden. Also, the costs which are associated are actually reduced, so there is no burden on the common man in this regard. There is reduction of dependency on lot of extra constitutional forums for justice, so that you don't really have to create other forums, other specialized forums, and all of those matters are kind of discussed at the level of gram sabhas. It brings justice to the doorstep. Like I said, that there are mobile courts which are present, which help you go to those, which helps justice to be provided at your doorstep. So we are ultimately trying to provide societal harmony. All right, we are trying to prevent enmity to this, and the fact that you can try both civil and criminal cases just kind of broadens the ambit and gives it a status whereby people look up to it, and there's a sense of trust, and there's a sense of also accountability with regards to the gram nyayalayas, and the public participation is much wider in this particular sense. But there are, of course, a lot of issues which are associated with the gram nyayalayas, and they include that there is not much finances which are there with regards to the functioning of this particular gram nyayalayas. So besides functionaries and functions, you also need funds for the functioning, right? So there is also lack of infrastructure, because you need like spaces where these entire court like proceedings are going to be taking place. So there is a lack of infrastructure, proper infrastructure spaces which are missing in these areas. People who are not trained, lack of manpower, trained manpower is something which is a very big problem as to how will the people kind of run their entire process. Also, this central assistance is kind of very poor, because there's an absence of a special cadre of Nyaya Adhikari, which is essential for the successful functioning of these particular courts or these particular Nyayalayas. People are actually not aware about these government bodies and these functionaries, so they really are not aware that they can approach the gram nyayalayas and they can trust them, and what are the things that have to be done. So more awareness needs to be created in this regard. The existing gram nyayalayas are actually disposing very low level of cases, so the objective with which it was formed, it's still not getting addressed. Lot of non-cooperation is being there by the enforcement agencies, all right, who really don't want to adjust and cooperate. Also, there is a certain amount of reluctance of the state functionaries, that the state department doesn't really want to kind of bring in and involve themselves with the gram nyayalayas. Legal services basically set up at the taluk level are of course expected to reduce the dependency which is there on gram nyayalaya, but to what extent we can really achieve that is actually questionable. Also, there have been a lot of criticisms which have been leveled against the gram nyayalayas, because it says that the whole point that you will be settling the disputes, that is not getting achieved. Okay, and ultimately all of them are being referred to the district forums for justice. So the whole point of trying to reduce the burden from the districts and move to these courts is actually not fulfilled. Also, like I was just telling you, gram nyayadhikaris are actually absent in these particular states. There is a lot of ambiguity with regards to in what areas, to what extent these alternative dispute resolution mechanisms can really function. All right. Sometimes, in some cases, you have gram nyayalayas located in cities and towns. So the whole point of having mobile court or availability and accessibility is kind of refuted and disputed, because the villagers are not able to reach to that distance. As I said, awareness is something which is very, very poor amongst these particular individuals. Now, in this regard, we need to really work on improving our Nyayadhikaris in the entire system, try to incorporate these procedures in much more simpler manner so that it is comprehensible for the local public, and also if it's done in local language, just like we're trying to bring in the new education policy in the local language, if we try to also kind of mold these legal systems from English of very formal language to their local language and have that customization, it will really do wonders in terms of the understanding. The awareness can be done, some of the awareness mechanisms can be through seminars and press releases. Also, we need to kind of have a suitable location for the establishment of these gram nyayalayas so that that kind of a problem of access does not occur. We need to provide the necessary infrastructure from the state budget. So these are some of the reforms that you can really implement in trying to make this system much more strong and robust so that the whole purpose of having gram nyayalayas is going to be fulfilled. So I hope you have benefited from the discussion, and if you have understood, let me know by liking the video. Share it with those who are still not aware and not aware of this gram nyayalayas so that we can spread awareness even amongst them, and subscribe for more and the final video of dispute redressal mechanisms.